In our second part regarding cybercrime in Indian scenario, we would like to discuss that the first ever act to combat cybercrime in Indian scenario was the Computer Fraud and Abuse Act 1986, and further the Landmark Act, which was enacted by the Indian Parliament, was the Information Technology Act 2000, and that act which was enacted, the very purpose of the act to investigate the very process of investigation of cyber crimes and the punishment. So, in section wise, we would like to discuss the very provisions of IT Act. So, under section 43 of the IT Act, it applies to individuals who indulge in cyber crimes such as damaging the computers of the victim without taking due permission of the victim. In such a situation, if a computer is damaged without the owner's consent, the owner is fully entitled to a refund for the complete damage. And as regarding section 65 and section 66, which applies to any conduct described as under section 43, that is dishonest or fraudulent, there can be up to 3 years of imprisonment in such instances or fine up to Rs 5 lakh. And as regarding section 66B, that we found, this section describes the penalties for fraudulently receiving stolen communication devices or computers and confers a possible 3 year prison sentence depending on the severity. A fine up to Rs 1 lakh may also be imposed. And now we would like to go to section 66C, and which made its main focus on digital signatures, password hacking, and other forms of identity theft. This section imposes an imprisonment up to 3 years along with 1 lakh rupees as fine. And as section 66D of IT Act, which in particularly provides regarding any involvement in cheating by personation using computer resources. Punishment for this kind of crime can be imprisonment up to 3 years and or up to fine rupees 1 lakh. And section 66E of the IT Act, which provides that taking picture of private areas, publishing or transmitting them without a person's consent is punishable under this section, and the penalties for any crime committed, and if anyone found guilty under this section, can be imprisonment up to 3 years and fine up to Rs 2 lakh. And section 66F, which provides the act of cyber terrorism. So any individual convicted of a crime can face imprisonment of up to life. As for an example, when a threat email was sent to the Bombay Stock Exchange and to the National Stock Exchange, which challenged the security forces to prevent a terror attack planned on these institutions. The criminal was apprehended and charged under Section 66F of the I.P.C.Act and Section 67 of the I.P.C.Act provides that anyone involved electronically publishing obscenities or anything damaging the morality or public order, if anyone convicted committing such activities which are either obscene or immoral, the person would be in prison for a term of 5 years and a fine up to arrest 10 lakh. And now we would like to discuss those provisions under Section 66A, which is in to some extent violate provisions of Article 19 Clause 1 and which was finally struck down by the Supreme Court in 2015 in the leading case Shriya Singhal versus the Union of India. And now we would like to discuss the very provisions of the amendment to the I.P.C.Act. So, in these amendments of I.P.C.Act, certain rules are framed, and those rules we would like to discuss. So, the first rule, that was the rule of 2011, and according to these rules, which entitle holding individual sensitive personal information, must maintain certain security standards that are specified, and those rules which are framed in 2021, it maintains the safety online users' data. These rules govern the role of intermediaries, including social media intermediaries, to prevent the transmission of harmful content on the internet. And the 2011 rules also provides those guidelines regarding cyber cafes which must register with an appropriate agency and maintain a record of users' identities and their internet usages. And the same 2011 rules also provide regulations, give the government the authority to specify delivery of certain services such as application certificates and license by electronic means. And the rules framed in 2013, these are those rules which provide for working in accordance with Rule 12 of the Central Electronics Technology Rules, a 24-hour incident response help desk and must be operational at all times. Individuals, organizations, and companies can report cyber security incidents to threaten if they are experiencing a cyber security incident. These rules provide an annexure listing certain incidents that must be reported to the cretin immediately. And in connection to cybercrime, we found those provisions under Indian Penal Code, which also punishes for cyber crimes. So, as per Section 292 of the Indian Penal Code of 1860, the very purpose of this section was to address the sale of obscene materials. However, in this digital age, It has involved to deal with various cyber crimes as well. A manner in which offense material or sexually explicit acts or exploitation of children are published or transmitted electronically is also governed by the provisions of Section 292. The penalty for such acts is imprisonment and fines up to 2 years and arrest 2,000 respectively. The punishment for any of the above crimes may be up to 5 years of imprisonment or a fine up to arrest 5,000 for repeated or second time offences committed under this section, and Section 354C of the Indian Penal Code provides that cybercrime is defined as taking or publishing pictures of private parts or actions of a woman without her consent. In this section, this exclusively includes watching a woman's sexual actions as a crime in the absence of the essential elements of this section. Section 292 of the Indian Penal Code and Section 66E of the Information Technology Act are broad enough to include offences of an equivalent nature. Depending on the offence, the first-time offender can face up to 3 years in prison, and the second-time offender can serve up to 7 years in prison. And Section 354D of the Indian Penal Code, which provides that stalking, including physical and cyber stalking, is described and published in this chapter. The tracking of a woman through electronic means, the internet or email, or the attempt to contact her despite her disinterest amounts to cyber stalking. This offense is punished by imprisonment of up to 3 years for the first offense and up to 5 years for the second offense, along with a fine in both the cases. And as regarding Section 379 of the Indian Penal Code, it provides that under this section, for theft can be up to 3 years. In addition to the fine, the I.P.C. section comes into play in part because many cyber crimes involve hijacked electronic devices, stolen data, or stolen computers. And now we would like to discuss the provisions of Section 420 of Indian Penal Code, which deals with cheating and dishonesty inducing delivery of property, for which 7 year imprisonment is there, in addition to a fine which is imposed under this section on cyber criminals doing crimes like cheating, fake websites, and cyber frauds. In this section of the Indian Penal Code, crimes related to password theft for fraud or the creation of fraudulent websites are involved. And now we'll go to section 463 of the Indian Penal Code, which involves and provides falsifying documents or records electronically. Spoofing emails is punishable by up to 7 years in prison and a fine under this section. And now we will discuss about the provisions of Section 465 of the Indian Penal Code, which provides that typically it deals with the punishment for forgery. Under this section, offences such as spoofing of email and the preparation of false documents in cyberspace are dealt with and punished with imprisonment ranging up to 2 years or both. And now we would like to discuss the last most important section of Indian Penal Code in relating to cybercrime is Section 468 of the Indian Penal Code, which deals with fraud committed with the intention of cheating may result in a 7-year prison sentence and a fine. This section also punishes email spoofing. So, besides that, we found certain other important acts which also deals with cybercrime such as the Companies Act 2013 with the rules framed in 2014. So, a majority of the corporate stakeholders consider the Companies Act 2013 to be the most pertinent legal obligation to properly manage daily operation. The Act enshrines in law all the techno-legal requirements that need to be met. Implementing the law as a challenge to the companies that are not compliant. As part of the Companies Act 2013, the Serious Fraud Investigation Officer is entrusted with powers to investigate and prosecute serious frauds committed by Indian companies and their directors as a result of the company's inspection, investment, and inquiry rules 2014 notification. The serious fraud investigation officers have become even more proactive and serious in regard to this by ensuring proper coverage of all the regulatory compliances. The legislature ensured that every aspect of cyber forensic e-discovery and cyber security diligence is adequately covered. Moreover, the company's management administration rules 2014 prescribed a strict set of guidelines that conform the cyber security obligations and responsibilities of the corporate directors and senior management. And in connection to that also would like to discuss the very role of the Reserve Bank of India. So the Reserve Bank of India Act, that is the Act of 1934, also provides guidelines and rules in controlling cybercrime. So, besides that, we found the cybercrime framework, and that important framework that was enacted and formed as cyber security framework, and that national cyber security framework as the most credible global certification body. The National Institute of Standards and Technology has approved the cyber security framework as a framework for harmonizing the cyber security approach to manage cyber related risks responsibly. The cyber security framework includes guidelines, standards, and best practices. So, according to this framework, flexibility and affordability are of prime importance. Moreover, it aims at fostering resilience and protecting critical infrastructure by implementing the following measures. So, in the very second part, relating to cyber crime in Indian scenario, we have discussed two important measures enactments dealing with cyber crimes, that is the Information Technology Act 2000 and its rules framed in 2011, 2021 and 2023, and also in that connection we have discussed the relevant provisions of Indian Penal Code and also the Companies Act 2013 and those rules of 2014 and those guidelines are rules framed by Reserve Bank of India. And as we have almost discussed these necessary important acts connecting to cybercrime scenario in Indian context, that to combat cybercrime in India, and another important major piece of legislation, and that is the Digital Personal Data Protection Act 2023, which also an important framework or a piece of legislation which also aimed at to combat cybercrime in India, but this act is not at came into effect. So in that context, we could explain that in our previous lecture. Already we have discussed in detail about the Digital Personal Data Protection Act of 2023 and those rules which are drafted in 2025. And in our next lecture, we would like to discuss those important leading cases or landmark judgments relating to cybercrime in Indian scenario.